Thank you, Eric. My name is Andrew Chin. I teach patent law at the University of North Carolina, and I had a previous life as a computer science professor. I have the easiest job today, which is introducing two men who need no introduction. Richard Stallman, though we know is the founder of the free software movement, co-founder of the League of Programming Freedom, lead software architect for the GNU project, and author of Emacs, which he's described as a text editor and also a way of life, something that I can agree with, having written my doctoral dissertation on using his program. Dr. Stallman has decided not to participate in the live streaming facility for today, and he explains that the streaming, the use of the streaming online would require use of the Microsoft Silverlight plugin, which would pressure people to use proprietary software that Dr. Stallman considers it wrong to pressure people to do that. So he would like you to know that he plans to make the recording of his presentation available at a later time in either the Augtheor or WebM formats. Dr. Stallman.
Can the tech people please confirm that the streaming is off? Okay, I think that's confirmation. So, why are software patents bad? Or computational idea patents, as I think we should really call them, because each one is a monopoly on a computational idea. Most people, when you say software patents, they think it's a matter of patenting a specific program. I'm sure all of you know that that's not what those patents do, but most people don't know that. So to try to avoid misleading people, I call them computational idea patents. So anyway, the reason these are bad is that they deny people the freedom to use their computers as they wish and do their computing as they wish. Freedom that everyone must have. These patents put all software developers in danger and their users as well. A danger that there is no reason we should stand for. So we should protect software from patents. Software needs patent protection, protection from patents. But most people don't know enough about what patents do to appreciate why patents that can restrict software are so harmful. Most people think that patents are like copyrights, which is not true at all. The sum total of what they have in common is one sentence in the Constitution, and that similarity is so little and abstract, it has nothing to do with the practical effects. So the last thing we should ever do is use the term, quote, intellectual property, unquote, that confuses not just these two laws, but a bunch of other unrelated disparate laws that don't even share one sentence in the Constitution with those two. So that term spreads confusion whenever it's used. And about 8 years ago, I decided I should never use it, and I have never used it since then. It's surprisingly easy to avoid, because in general, there's no reason whatsoever to use it except that it's chic. And once you learn to resist that, it's as easy as pie. Just talk about one law, and then you call that law by its name, and you're making a coherent, clear statement. So I have to explain to people what patents do and show them that it's not at all like what copyrights do. And an analogy is a good way to do this. What can you say about programs? Well, they're large works full of details that all have to work together to get the desired result. Well, what else is there like that? A novel or a symphony? So imagine if the governments of Europe in the 1700s had the cockeyed idea of promoting the progress of symphonic music with a system of musical idea patents. So any musical idea statable in words could have been patented. A melodic motif could have been patented, or a series of chords, or a rhythmic pattern, or a pattern of repetitions in a movement, or the use of certain instruments while the rest of the orchestra is silent, and a bunch of other musical ideas that I can't think of, but maybe a composer would. So now imagine it's 1800 and you're Beethoven and you want to write a symphony. You're going to find it's harder to write a symphony that you don't get sued for than to write a good symphony. Now, you'd probably have complained, and the patent holders would have said, oh, Beethoven, you're just jealous because we had these ideas before you. Why don't you go think of some ideas of your own? Of course, Beethoven is considered a great composer because he had lots of new ideas, and not only that, he knew how to use them effectively, and that is combined with lots of familiar ideas, so that his pieces were merely shocking for a while, but people could get used to them. They were not so alien and incomprehensible that they got rejected. They shocked people for a while, people got used to them, and now we don't see what's shocking anymore, because we're used to those ideas. Well, that's the proof that he used those ideas well. So, the idea that anyone could or should have to reinvent music from zero is absurd. Not even a Beethoven could do that, and it would be silly to ask someone to try. And it's the same with computing. Just as a symphony implements many musical ideas together, but the hard part is not picking a bunch of ideas. The hard part is implementing them together with notes. It's the same with software. A large program will implement thousands of ideas together, but the hard part is not picking some ideas. It's easy to pick some ideas. What's hard is to implement them all together and make it work well. So, computational idea patents obstruct the hard and big job by promoting resources that we get plenty of anyway. So it's a misconceived system designed to give us help we don't want at the cost of tremendous problems. So what we need is to get rid of the problem. And what is the problem? The problem is software developers and their users are threatened by patents. They're in danger. How can you prevent that? Well, one way is don't issue patents that could affect software. That solution works if you apply it from the beginning. If a country never issues such patents, then its patent system doesn't attack software. Okay, it's a good solution, but it's not applicable if a country has already issued hundreds of thousands of software patents. Now, I've proposed that Constitution should explicitly say that patent privileges can be reduced just as they can be increased, that they're not in any sense somebody's property. They are privileges given out by the government which can be changed at will. After all, if you allow the government by legislation to increase them, it's absurd to make this a one-way ratchet. But that's not in the US Constitution. So what can we do? Well, we can ask courts to rule that all those patents that restrict software were invalid from the beginning and always have been invalid, and that gets rid of them all. However, that's not something that people can lobby for. It's not something we can say to officials, do this because we want you to. So if we're going to look for a solution that we can get implemented, what is there? Well, the only way I can see is to legislate that software is a safe harbor. If it's software, then you're safe. Circuits to do the same computation would be covered by a patent, but if it's software, then you're safe. But what does that mean? What does it mean for something to be software? Well, it runs on a general purpose universal machine. So first you make a universal machine, and then you put in the program to say what it should do. Well, if the machine's only function is to be universal, then the program is all that implements any specific patented idea. So that's the case I want to get at, and I'm trying to separate it from a case like that in Diamond v. Deere, where there was a patent for a method of curing rubber, and the implementation involved a computer, but it also involved special purpose hardware, not a general purpose universal machine, and that special purpose hardware was crucial to carrying out the patented technique. It wasn't actually a software technique. And actually, I read an article by Pamela Samuelson arguing that the CAFC twisted that decision and basically got the quantifiers in the wrong order. But the Supreme Court said the fact that there's a computer in there somewhere doesn't automatically make it non-patentable, and the CAFC twisted that into the computer makes it patentable. Anyway, I see. So, we might have some hope with the courts, but I'm proposing a method that will separate the cases that we must protect from non-computational idea patents that affect systems that might be implemented with a computer in there somewhere. The precise words to use, well, the best I could come up with was software running on generally used computing hardware. We certainly want things like smartphones to be covered. We don't want it to exclude anything that has any kind of special purpose hardware in there. The portable phone obviously has specialized hardware to talk to the phone network, but that shouldn't automatically mean that if it's running on a portable phone, it's vulnerable to patents, because that is a general purpose computer and people use it for all sorts of things. But my words, generally used computing hardware, they may not be the best possible words. This is a subject that I think calls for study, because we've got to look at each possible wording that might be used and see which cases would be protected from patents and which would be exposed to come up with the right method. Now, every time I suggest a method to solve this problem, the first thing people try to look for is how to half solve it instead. The idea of really solving the problem shocks people because it strikes them as radical. They think, I can't advocate something so radical as to really solve this whole problem. I've got to look for some partial solution that will only protect some software developers. Well, that's a mistake. It's a mistake, A, because it wouldn't do the whole job, but B, because it would be harder to get it passed. There are lots of software developers and they're all threatened, and if we propose to protect them all, they will all have a reason to support it. But if we propose to only protect some of them, the rest will say, well, this doesn't do me any good, why should I care? So let's propose a real solution. And besides, partial solutions tend to be vulnerable to the problem that Boldrin and Levine have written about very effectively, that it's easy for the pressures for patents to stretch the boundaries if you give them any kind of boundary that they can stretch. And this, by the way, is another advantage of applying a change to suing people rather than to what's patentable. Because there, the criteria are just what kind of situation is this? It's harder to stretch those, and if they tried, it would always be in a case against somebody who's going to be fighting not to stretch it. So it's less vulnerable to being distorted from an intended restriction of substance into an actual requirement of form of patent applications, which tends to happen to any kind of requirement about what patent applications have to look like. So there I go.
Thank you, Dr. Stallman. Kent Walker is Senior Vice President and General Counsel at Google, a company that's at the leading edge of many of the issues we're discussing today. In previous positions he's held include senior legal positions at eBay, Liberate Technologies, Netscape, and America Online. Google is a company also whose mission statement to organize the world's information and make it universally accessible and useful would seem, at least in principle, to be compatible and even complementary to the manifestos developed by Dr. Stallman in connection with his free software movement. We'll be interested to hear whether that compatibility can also work in practice. Mr. Walker.
Great. Thank you very much. Thank you to the organizers, and it's obviously a timely and important session with a lot of the leading lights in the field assembled, and we appreciate that, and we look forward to what's coming, we hope will come out of this conference. Google, as you've probably seen from the news, is in the midst of a number of different patent challenges at the moment. We feel as though we're really in the trenches, and in my comments this morning I'd like to complement some of Richard's observations with our concrete takeaways from what we're seeing in the field and offer a few suggestions of our own as to how we might make things better. It's notable, we were saying in a conversation this morning, that Article 1, Section 8 is the only provision in the Constitution which has its own built-in test of effectiveness. You know, are we really furthering the progress of science and the useful arts? To assess that sort of data-driven challenge, and we'd like to think of ourselves as a data-driven company, it's useful to look at a lot of the statistics that we're seeing coming out increasingly about the performance of software patents and the effect on the software sector generally. It seems clear that we have a patent quality problem. The average examiner has only 15 to 20 hours to review a patent application, and when the PTO does re-examine a patent, that patent has its claims altered or canceled between 78 and 89% of the time. It seems clear that we have a litigation problem. More than 4,000 patent lawsuits were filed in the US in 2011. That's the highest number ever, with internet patents litigated about 9 times more often than patents as a whole. And most specifically and urgently, it seems we have a problem with non-practicing entities, trolls. 40% of patent suits in 2011 were filed by trolls. That's almost double the number, double the percentage from 2007. While 90% of the cases filed by trolls settle, when they do go to court, trolls lose 76% of the time. And recent studies estimate that troll claims last year cost US companies $29 billion in direct payouts, almost $80 billion a year when you take all costs into account. So $29 billion to $80 billion a year. By comparison, in today's dollars, it took the United States of America about $12 billion to build the Panama Canal. So we are costing ourselves some number of Panama Canals every year because the system isn't working the way it should. I think those numbers support the hypothesis that trolls are exploiting flaws in the system, especially for software and internet patents. We see trolls in a sense as the sharp end of the spear, the clearest manifestation of how it's become easy to exploit problems with software patents more generally. No one thinks that people should be able to exploit questionable patents to extort productive companies and to block products from consumers. but that's exactly what appears to be happening. Tech companies like Google and Facebook and HP and Amazon face hundreds of lawsuits and have seen a remarkable spike in recent years. These are companies that know from firsthand experience that execution matters as much as ideas in creating great products for consumers. Facebook wasn't the first social network, but it thrived because it executed well. Google wasn't the first search engine, but we executed in ways that delivered better results for our users. It's products and services, not legal claims, that improve the lives of millions of Americans and billions of people around the world. These are companies who, in Teddy Roosevelt's phrase, are in the arena. We do the hard work of creating real products and real services for real people. But it's no secret that the patent arena is not a pretty place to be right now for companies or for consumers. The troll problem is big, and it's getting bigger. It's a tax on innovation that forces productive companies to waste time and resources on litigation that would be better spent in building great products. Many of the troll suits that we've seen seek to exploit bottom-of-the-barrel software patents. These are patents that claim common business methods performed on the internet, like showing an ad before a video, or patents that are ridiculously broad, like claiming ownership of the interactive web. Google and other large companies can fight back, but patent suits pose a real drag on small companies, startups, independent software engineers. So why is it that the trolls prey especially on tech companies and tend to exploit software patents? There are a few reasons. Everybody in the audience probably has their own. But it's clear that software tends to evolve quickly and depend on cumulative crowdsourced innovation. So it's easy to jam a stick in the spokes. RPX estimates as many as 250,000 patents might read on a smartphone. The broad and often ambiguous nature of software claiming makes it easy to assert a claim that covers potentially a vast number of implementations, including technology that hasn't really been invented in any meaningful sense for years to come. Of course, it hasn't always been that way. In the 90s, our most successful tech companies had few patents, and patents weren't seen as central to the innovative process in software. But today, the torrent of software patent litigation has become a waste for society. Companies are spending billions of dollars managing the threat through taking licenses, paying fees to aggregators, and building large portfolios for defensive purposes. It's a classic deadweight social loss. Moreover, operating companies are increasingly selling off patents to trolls, either due to pressure to monetize those assets, or in some cases as a way to inflict harm on industry rivals. This trend presents a serious threat both to innovation and to competition. And we were glad to hear the FTC's announcement that they'll be exploring the issue at an upcoming workshop in DC in the next month. We need to refocus the patent system to support the ability of innovators to deliver on great ideas, not the ability of lawyers to game the system. To do this, the administration, Congress, and the courts can apply traditional patent law concepts, but do so with a greater understanding of progress and innovation in the software industry. So what do we think should happen? What's the path to making things better? We are making progress. The en banc rehearing by the Federal Circuit of the CLS case is a positive marker. The PTO's Section 112 guidelines for examining software is definitely a move in the right direction. And the new programs that are just getting started for weeding out bad patents under the American Invents Act may also prove a way of addressing some of the past problems. The generation of poor software patents that were issued as a pig in the python. And we'll see how that plays out in the coming years. But we clearly need to do more. As the 7 or 8 year fight over the American Invents Act showed, it's hard to get consensus among a variety of industry groups and players for broad changes to a complex system. But again, by extending traditional patent concepts in the context of software development, we believe we can address some of the worst abuses. We have 3 practical recommendations along those lines. First, at the highest level, let's stop bad software patents from issuing. Patents should be about creative production, not creative writing. If we apply traditional patentability standards with an understanding of how innovation happens in the software industry, we will come to a better approach that focuses and demands better descriptions in software patents and clearer claims that map the real contribution, not elastic claims that trolls can later stretch to cover products that the applicant never imagined, let alone really invented. We would never allow a patent on any combination of molecules that might cure a headache using a pill. But we regularly allow patents on every possible way of implementing a simple transaction when done via a general purpose computer. Second, we should weed out the bad software patents that have already issued. When the Federal Circuit first allowed software patents in the 1990s, the floodgates opened, and we've seen a large number of trivial and sometimes even poorly examined patents. That pig in the python continues to plague the industry and software development, and we need better tools to deal with it. The American Invents Act already set out a path for challenging financial sector business method patents, and we believe Congress should extend that to cover all software patents, not just a select few. Third, we need clearer rules for damages and awarding costs. The prospect of lottery ticket damages awards, like the recent $368 million award against Apple, encourages abuses by trolls, not real product innovation. To stop abusive patent litigation, courts should come up with clearer and more predictable approaches to patent damages. And Congress should find ways to make it easier to recover attorney's fees spent defending against frivolous, meritless cases, such as the SHIELD Act, introduced by Representatives DeFazio and Chaffetz. In the meantime, companies aren't waiting for fixes from Washington. Google's launched Patent Search, making it easier to find prior art. Stanford has launched Lex Machina, providing better data about the problems of abusive troll litigation. Cisco recently filed a RICO suit against a serial plaintiff. Groups like RPX and AST are trying to defang the worst of the problem. And companies are increasingly looking to defensive patent pools and other innovative approaches to reduce patent risk. But while self-help is good and necessary, it isn't ultimately going to solve the larger problem for companies or for consumers. We have to improve our patent system to reduce the troll tax so that companies can stop wasting money in court and get back to what they do best, building great products and services that we all enjoy. Thank you.
Thank you, Ken. In the interest of time, in lieu of asking the first question, I'll put in a plug for my own position paper, which I'm told just went online on wired.com. It's a proposal to have a concrete causation standard for software inventions, and it's responsive to some of the points made by Kent and also by Mark Lemley. And with that, I'll open it to the floor. Yeah, question.
I have a question primarily for Mr. Stallman, but Mr. Walker, feel free to answer also. Mr. Stallman, do you have a good definition of what a software patent is that we can use in any proposed legislation or?
Well, as I've said, I don't propose to distinguish between computational idea patents and other patents in legislation for the U.S. Because that would only affect the issuance of future ones. So my solution avoids the need. I distinguish between software scenarios and non-software scenarios, and I exclude software scenarios from the threat of patent infringement lawsuits, and they're protected.
But how do we define software?
Oh, well, that's pretty easy. I mean, software is something that runs on a general purpose computer. So the question is, which of those cases are accepted? Because there are general purpose computers built into some specific special purpose hardware that you might not want to exclude, like the rubber processing factory. But what's clear is that if it runs on something like this or on any of today's mobile computers, those cases should just be completely excluded. Any software running on one of these should be excluded, or one of those, or I'm not interested in any measures that presuppose we should try to identify, quote, the bad software patents, unquote. That's easy to do. The only good computational idea patent is a dead computational idea patent. They're all bad. It's a mistake to talk about the bad ones as if any could possibly not be bad.
Let me weigh in.
I have a question about I'm Tice Winarski. I'm a senior licensing attorney with Intellectual Ventures.
Excuse me, Mr. Walker, I think, wanted to respond.
Just one other thought, I'm sorry, I couldn't see the speaker there. One thought on that, I wouldn't purport to answer the question directly, but rather to sound a note of caution. I think it is politically challenging to start to draw hard lines between different sectors because of some of our experience with the AIA tells us that there are a number of folks in Washington who have constituencies that are interested in different categories of patents that resist that notion of trying to move away from a unitary patent system and having a what they will call silos for different treatment. I think it is perhaps more feasible to urge the PTO and Congress to take more notice of the different contexts in which software arises. There may be, we believe that there are, aspects of software development, the nature of the terminology that's used in describing software claims, the way that software is articulated in terms of the specifications in the claims. Mark Lemley has done a piece on functional claiming that Andrew referred to, that may be sort of specific instantiations of more general principles that may be, with deference to Richard's point about the need for a comprehensive solution, may be more politically feasible as we move forward.
Thank you. Please go ahead.
My question is, why doesn't Europe dominate the software industry? Europe, as you know, does not grant software patents, where the United States does, but it's not clear that Europe has any advantage over the United States. So despite all the haranguing we have about software patents, it's not clear to me that not granting them is giving Europe's software industry any edge over the United States.
I'm not sure that that's even a meaningful concept. How do you judge which part of the world dominates another part of the world in software? I think it's a bogus issue. Meanwhile, in fact, there are lots of software patents issued by the European Patent Office, which, like patent offices generally, has the tendency to want to stick its fingers into more pies. And if you've ever seen the image, "Your web shop is patented," it lists a bunch of patents issued by the EPO on common activities in web shops.
Just to add to that, I think much of the flowering of the U.S. software industry came in the 80s and 90s before there was any meaningful software protection in the United States. Moreover, I think it's almost overdetermined when you ask why technology and software has flourished in the United States. We have safe harbors for internet development. We have a very entrepreneurial culture. We have the unique combination of economic resources and entrepreneurial resources and engineering talent. They've made the United States one of the world's leaders in software development, but technology development more generally. And I'm aware of no studies that suggest that the availability of software patent protection has been a meaningful driver in that.
I saw a hand over there.
Developers and users have to be free to use computers in the way we want. So you're focusing on those aspects of the chain. What about the developer who does create, and I would even use the word invent, some very useful, powerful, elegant solution that even you would recognize as being
Why
innovative?
should we be particularly concerned with that person?
Does that person have a right or have some interest in protecting their development?
It's not in danger from anything except other people's patents. No, I reject the premise of this. That person, the idea that we should be so concerned for somebody who has an idea in the software field that we should hand that person a gun to attack everyone else in the software field is ludicrous.
So then you would agree then the same argument can be made in any other domain.
No,
let me just finish.
No.
Mechanics and engineers need to be free to use their equipment in their shops to build physical devices.
No, I don't make that claim. I think that there is an important difference between the software field and others. Actually, there are two. One is everybody does software, and in particular, businesses in all activities do computing. That's not the case for something specific physical like engineering. There really is, for instance, an automobile industry, and only a tiny fraction of businesses in the U.S. do anything that it has to do with making cars or car parts. You go to a restaurant, they don't make any car parts. You go to an accounting firm, they don't make any car parts. It makes sense to identify the automobile parts industry if Bain hasn't shipped it all overseas yet. There's no such thing as the computing industry because every business does computing. Second, there is a fundamental quantitative difference between software and other fields in how many ideas you could put together into one thing. That's because software design is easier than engineering that has to cope with the perversities of matter. Well, the people have the same intelligence range in all these fields. You give them something fundamentally easier, they do bigger things. So you could a few people can implement thousands of software ideas together in a few years. They couldn't do that in physical engineering. So the result is that one package, one thing that people make is threatened by a lot more patents in software than in other fields. That said, I'm not going to defend patents in any other field. Boulder and Levine's argument that we should have no patent system at all seems fairly strong, but I'm not in those fields, and I'd rather not take a stand on patents in a field such as auto parts. But there are reasons why software is different.
Please join me in thanking our excellent keynote speakers.